In the context of RERA, agreement for sale has been defined under RERA Act. Section 2C defines agreement for sale as agreement for sale means an agreement entered into between the promoter and the allottee. So now the question rises, what is agreement? So agreement has been defined under Indian Contract Act. So what is agreement now? Agreement means every promises and every set of promises forming the consideration for each other is an agreement. And when the agreement is enforceable under the law, then section 2H says it is a contract. Therefore, any agreement between the promoter and the allottee would be termed as agreement for sale. So sale agreement, also known as sale deed, is a contract or an agreement through which an immovable property is transferred from seller to the buyer. The property is an existing property, and such contract are known as executed contract because all the risk and the liability attached to the immovable property is also transferred immediately. Whereas in comparison to the agreement for sale, all the risk and the liabilities are transferred on a future date, and such type of contract are known as executory contract. So in real estate, agreement for sale plays a very important role. Why? I will like to share 2-3 points. Point 1, real estate sector is the only sector where a product is sold which even doesn't exist on the sale date. For an example, when a person buys a flat on the 5th floor, when he invests or when he pays for it, the construction is only at 1st floor. So he is paying for a product which is not on the date of payment is not even existing. Second, when you buy a flat or apartment in under construction project, you are not buying a flat or apartment because it doesn't exist. You are buying an agreement, a contract which will decide how your flat or apartment will look at the later stage when you will get the possession. Therefore, your agreement for sale will decide everything about your dream house. This agreement will decide the following about your dream house. 1. How big you will get it, when you will get it, what are the amenities you will get it, which specification, which tile, which flooring, how the kitchen would be, will you get the parking or not, will you get the clubhouse or not. All this would be decided by agreement for sale. Not only that, under section 18, from when the compensation will start, how much compensation you would be receiving would also be decided by this agreement for sale. Whether it is a promoter or the allottee, agreement for sale is equally important when the other party defaults. Allotment letter is the first stage when allottee buys the flat or the apartment. So to understand first the difference between allotment letter and the registered agreement for sale, we need to understand the timeline first. So when a promoter open a booking for a real estate project, the first thing, when the allottee pays as a token amount, he will get either acceptance letter, which can be also termed as provisional letter and commonly known as allotment letter. Then he will make further payment, he will get receipts, and then finally he will enter into agreement for sale, which will be registered under appropriate law. Now, what can be termed as agreement for sale in this? It can be termed as allotment letter, receipts can be termed as agreement for sale, or can only registered agreement for sale can be termed as agreement for sale. So for this, RERA as well as Maharashtra Real Estate Appellate Tribunal has already given judgment which states that the allotment letter can also be treated as agreement for sale. In Vinay Jairam Salian versus Keenpath Real Estate, Maharashtra Real Estate Appellate Tribunal decided that even allotment letter can be termed as agreement for sale if it contains all the conditions and all the points which an agreement for sale should contain. Also, in another case, Manjit Singh Dilwalia versus JVPD, Maharashtra Real Estate Appellate Tribunal decided that an allotment letter or letter of acceptance or provisional letter or provisional agreement, by whatever name called, if it contains all the conditions which were agreed between the allottee and the promoter and there is no other additional things which is left for negotiation, then such letter, which is allotment letter, can also be termed as agreement for sale. In one of the cases, RERA authority termed MOU as agreement for sale because MOU contained all the details which an agreement for sale should contain. Not only that, such an MOU also contained when the agreement for sale will be entered. In Lavasa Corporation, the Bombay High Court decided that even a lease deed can be termed as agreement for sale if it contains all the ingredients of agreement for sale. In that case, the lease deed was entered for 999 years and the lease amount was only 1 rupee, and the amount which was received at the time of giving such villas to the allottees was termed as lease premium. The Bombay High Court took a stand that the amount which is paid by the allottee to the Lavasa Corporation would not be termed as lease premium but would be termed as the consideration, and hence the agreement for sale was equivalent to lease deed in such cases. Further, Income Tax Appellate Tribunal has also decided that the allotment letter can be equivalent to agreement for sale, and in such cases the assessee can take the benefit of Section 54 of Income Tax Act. Agreement for sale is an important document which forms the transaction link between the promoter and the allottee. Therefore, agreement for sale is not only important for the allottee, it is equally important for the promoter also. Now, what would be the content of an allotment letter which will equate the allotment letter to agreement for sale? For that, it should contain some specification, some content, some points. So what are these? Point 1 would be the project name with the project registration number which is registered with RERA authority. Sales consideration with all other charges. All facilities, amenities, specification. 1 pertaining to the flat, 2nd pertaining to the common area which the allottee would enjoy. Possession date, the schedule or the timelines which the allottee as well as the promoter will be bound with it. The compensation in case allottee defaults in payment at the given time or the promoter defaults in giving the possession in time. Whether the project is mortgage, and if yes, how much, and whether there is an unpaid amount by the promoter to any authority like the land authority or the revenue authority. Now the most important, this allotment letter should contain a clause which should says the agreement would be entered later and would be registered under appropriate act. Further, the agreement would be entered later would be as per RERA given under model given as per model agreement, and all the terms and condition as decided in allotment letter would form the part of agreement for sale. One more thing, the allottee should take care whenever he pays more than 10% of the sale consideration, he should insist the promoter to first enter into agreement for sale, and the same should be registered under appropriate law. Agreement for sale is important. However, the registration of real estate project is also equally important.